Good afternoon, and welcome to the very first meeting of the Civilian Police Review Board. It's been a long time coming, but the day has finally arrived for this meeting. Before we get started with introductions and following the agenda, I really feel that it's necessary for me to say some thank yous, and I hope it's not too long of a list. The first list, actually, the first person goes back to the mayor and his decision to actually convene the Columbus Community Safety and Advisory Commission. And I have a huge thank you to the other 16 members of that commission who met for, I think, almost 18 months, resulting in the commission providing the mayor and council with 80 recommendations. And we did that in January of 2020. I then want to thank both Mayor Genther and Council President Harden and the other members of council for taking the lead to place the two charter amendments on the ballot for election last November, the one that both creates the Civilian Review Board and the Office of the Inspector General. And certainly a huge thank you to the almost 74% of the citizens who voted, I'd say overwhelmingly, for those two new provisions of the charter. And then there's a group that we didn't hear from that much, but they did great work. There was the work group that was appointed by the mayor, who came up with, I believe, 17 recommendations for the Civilian Review Board. Some of those recommendations have already been incorporated. Others we will look at a later time. But again, I just felt that there have been so many individuals who've been working on this for such a very long time that collectively we need to say thank you. And then finally, to each of you, thank you for wanting to serve, for applying, for going through the process of being interviewed, and for now actually serving. I am truly looking forward to working with you. And I guess in this case, it's not months, it's years to come. So thank you again for being here today. At this time, I think it's, and you know, I'm not sure if when I started, I actually said who I was. So I'm Janet Jackson. I am the chair of the board. I have served this community really for decades, for 10 years as a municipal court judge, 6 years as the city attorney, 14 years as the CEO of United Way, and then serving on the Safety Advisory Commission, and now serving as the chair of the board. So I will say it for you, I have failed retirement. We know that now for sure. But it is truly my honor to serve in this capacity. So now we're going to have the members of the board introduce themselves. I'm going to start here with my right with board member Mary Younger, and then if we could just go around the table.
My name is Mary Younger, and I'd like to thank the mayor and the city council for allowing me and giving me this opportunity to serve on this board. I am truly honored. I come to you from 36 years as a criminal defense attorney in the Franklin County Public Defender's Office. I have worked hard all my life doing criminal defense for the indigent. It has been, being a public defender was also an honor. And I worked very hard, and people that know me know that I will work hard, and I will work hard for the city of Columbus. I think that this is necessary. The citizens wanted it, they need it, and we have a responsibility to them, and I will do my best. Thank you.
I'm Rich Nathan, and graduated from the Moritz College of Law at The Ohio State University, and then taught at Ohio State for 5 years, made a career switch and entered ministry, and am the founding pastor of Vineyard Columbus, where I've been serving for the past 34 years. So great to be with you.
I'm Willard McIntosh Jr. I was with the Columbus Police Department for 31 years and 7 months. Currently retired, And I am honored, it sounds cliche, but I am definitely honored and humbled to serve on this committee. But unlike Janet Jackson, I don't plan to fail retirement. Thank you.
Hello, Randall Sistrunk. First of all, it's a pleasure and an honor to be here. I'm really excited to get to work with such a group of accomplished individuals. Mac, as I will call you, thank you for your service. I've worked alongside of you, and I know that you're passionate and dedicated to this work and helping people, and I'm looking forward to work with you. So I've spent quite a few years working in the criminal justice field, from running reentry programs to working directly with incarcerated individuals. A lot of professional and personal experiences working with law enforcement. So I'm really honored to have a voice at the table, and I'm really honored to get to work. And I'm just going to leave it there. Thanks.
Hi, I'm Brooke Burns. I am Chief Counsel of the Juvenile Department at the Ohio Public Defender. I've spent the last 16 years working with youth who are incarcerated in Ohio's juvenile and adult prison systems. I was also a member of the Safety Commission that made the recommendation that this board exist. In addition, I'm also a professor of juvenile law at Capital University, and so am uniquely interested in specifically youth and police interaction, which is what led me to the Safety Commission and ultimately led me to making a recommendation for the board. So happy to be here.
Hello, everyone. Good afternoon. My name is Aaron Thomas, and I am a member of the Columbus community. I've been here since 2003. I came here for college. Currently, I am employed by The Ohio State University in the College of Medicine, and I run a pathway program for students who are historically excluded from health and medicine who are interested in pursuing a career or an advanced degree. And so I want to thank the people who advocated on my behalf to be included on this board. I was not originally selected to be included on this board, but as the community saw need for the board to expand to be more representative of people like myself who are in the community, I appreciate them for that work and for the charge that I have to be here today to see what our board is going to do and see if our community can actually trust the board, and so that after our first, I guess, go-around, more people will have buy-in to join, and that the board will reflect the rest of our community. So thank you.
Thanks so much. Good to be here. Good afternoon. My name is Kyle Strickland. I'm an attorney at the Roosevelt Institute and at the Kirwan Institute here at Ohio State University. Grateful to be here, honored to be a part of the Civilian Review Board, and like to thank the City of Columbus. This is going to be hard work ahead, and I know that it is not without its controversy. But what I think is important about this review board and the task ahead is that we have a diverse group of people here who are going to represent the residents of the City of Columbus. We are not going to agree on everything, and that is a good thing. We shouldn't agree on everything. But this is a process that's going to require intense commitment, and I know everybody on this board is committed to this, and I think the most important aspect of this is transparency, independence, and building trust within the residents of the City of Columbus. So I'm looking forward to this review board, and it's an honor to be on board. Thank you so much.
Good afternoon, everybody. My name is Mark Fluharty. I'm the Executive Director of the Central Ohio Labor Council, AFL-CIO. I have been part of the labor community here in Central Ohio for over 30 years. I've been the director at the Labor Council for the last 3. But prior to that, I worked at the United Food and Commercial Workers, which represents Kroger, Meyer, CVS here in our community. So I've been a representative of working people for over 30 years. I'm extremely happy to be here. I think I bring a lot of talent here when we talk about discipline and things that we're going to address in the future. I look forward to working with everybody. Looks like a great group. And yes, it is going to be quite the challenge. And just like Chair Jackson, I also failed at retirement. Thank you.
Excuse me, has not joined us. When she does join us, we'll give her the opportunity to introduce herself. Sorry, Pastor.
All right. Charles Tatum, pastor of the Good Shepherd Baptist Church and also chairperson of the Concerned Linden Clergy Group. I have served in the pastoral capacity now for over 20 years, been in ministry for 42 years. We've had opportunity to do all forms of ministry, street ministry, justice ministry, which we just stay engaged with. I'm glad to be a part of this review board because I want to be a part of something that's going to be able to bridge the gaps between those who police us and those in our communities. I want us to be able to work together. I want to be able to see people understand that justice is more than just a word. I look forward to being able to sit in this board and to listen. I want to be able to learn, and then I want to be able to serve. So I just thank you again for this opportunity. Look forward to being able to do positive things. I'm thinking positively coming into this work, because I believe that we can get it done. So thank you again.
Thank you, Pastor. Dr. Jones, we've just introduced ourselves. Your turn.
So I got here at just the right time then. Well, I guess, right? Just a little late. But the parking situation is messed up, so we're going to have to work on that, whoever organized this. But good afternoon, everybody.
Good afternoon.
For those of you who don't know me, my name is Dr. Chanel Jones. I'm the Assistant Dean of Community Engagement and also chair our public safety programs at Franklin University. So with that, I oversee our Criminal Justice Administration program, our Emergency Management and Homeland Security program, as well as our Public Safety Management and Leadership program at both the undergraduate level as well as the graduate level. And then I have 2 centers that I oversee, a Center for Public Safety and Cybersecurity Education, as well as a Global Center for Healthcare Education. So I do a lot. So that's the academic side. I also am the National Director of Research for a program called the Teen and Police Service Academy, where we pair police officers up with kids in mentorship dyads. And the purpose of the program is to reduce social distance between the teens and the police. We started that program actually when I was working on my PhD in Houston, Texas. It has since grown and expanded from Houston to most of your major cities across the U.S. and abroad. We're in the Caribbean. We pick hot cities except for Columbus. And so that's a little bit of the stuff I do. I was on the Safety Commission, and I look forward to doing this work. Most of my research is on policing and police community relations. And so I'm excited to dig in and get this going.
Thank you. It's great to see you.
Good seeing you, too.
I will probably have some housekeeping issues as we go up throughout our first meeting. So the one, because I'm not sure that everyone, heard this, our meetings are broadcast live, and so it will go live at 2 o'clock, so 2 until, we adjourn. And I do believe in staying within my time frame that has been set out. And then you can find out later it's rebroadcast. I think it's going to be Facebook, you name it, it'll be out there. But just so that you know, it is critical that we will get started at 2 o'clock. We have 2 special guests today, and I don't want to say that one is more special than the other, but I'm going to. I am thrilled that Chief Elaine Bryant is in the house today. On behalf of all of us, I welcome you to Columbus. We are so very glad that you're here, and we wanted to give you the opportunity to basically share whatever you wanted to share. As it turns out, we did change the agenda since the contract was ratified last Monday to have a representative from Baker Hostetler to come and to go over the contract, but she will do that after Chief Bryant shares.
Thank you. Good afternoon. Good afternoon. Honorable Board. It's a pleasure to be here with you all. As she stated, I am the Chief of Police, all of 39 days. Yay. So I'm excited to be a part of this process because coming in with you being new, being able to work with you from the beginning, I think is important. I think it's going to be a great relationship. I look forward to the partnership. I'm excited because I come from a department that had a review board, and our relationship was very positive. and it yielded very positive results. So I think that this is a great opportunity to be able to look at policies and review things that's going to move this department forward and bridge those gaps and those relationships between the community and our police department. So thank you for allowing me to be here with you and share in my thoughts in regards to where we're going and what we're looking forward to. And as I said, I'm excited to work with each and every one of you. So thank you.
Thank you again coming for today, Chief. Now, I didn't know if you needed to leave today, if you were going to stay with us for a while, or what did you want to do? I know you are very, very, and I was going to say this later. I think it's rather ironic that our first meeting is today. Today is National Night Out, and so the chief has many, many, many stops to make this evening, and I certainly understand that. So if you need to depart, we understand that.
I appreciate that, and I do. I am preparing for National Night Out. I will be across the entire community today, but I look forward to coming and being able to be a part of other meetings. So thank you so much for allowing me to come and say a few words.
Thank you. Thank you. So our next guest today is Jenny Edwards from Baker Hostetler. And again, I think I said this earlier, just really with the timing, since the contract was actually approved just last Monday night, and we were meeting fairly quickly after that, I thought that the board just might be interested in the contents of the contract. So invited Jenny to come and to present today. Jenny?
Thank you, Chair Jackson. It's an honor to be here with you all today. I look forward to seeing your service in our community and seeing the outcomes of that service. As Chair Jackson mentioned, Baker Hostetler leads the negotiations with the Fraternal Order of Police Lodge 9, which represents the police officers, sergeants, lieutenants, and commanders who serve within the Columbus Division of Police. We've had the great honor of representing the city in those negotiations for many decades, although I've not been a part of them for many decades, I'd like to just note. But we've been pleased to be able to represent the city, and particularly this year, very pleased with the outcome of the negotiations because we were able to be successful in reaching an agreement that allows you all to do the important work that you're doing, and also will allow for the appointment of an inspector general who will then have critically important work to do as well. I know that we are on a quick timeline, so I don't want to belabor, that's my pun, the point of how labor negotiations work under the Ohio Revised Code, but I did want to give a quick overview of why it was really important that we reach an agreement rather than allow this process to kind of stalemate and end up in an arbitration situation. So I'll take a quick minute to run through that, and then maybe. Got it. So we'll talk very quickly about the bargaining process in good faith, as well as the impasse process, and then the progress and negotiations that we were able to make. For some of you, this will be a review, particularly those of you who served on the working group board, or in the working group, because we did walk through some of that there. I just want to remind you that the obligation to bargain falls upon the city through the Ohio Revised Code. Chapter 4117 requires the city to bargain with the exclusive representative of the FOP, or of the police officers or the FOP. Throughout that process, we have to bargain in good faith, which means we have to come to the table and make sure that we're coming with appropriate proposals, that we are continuing to discuss and negotiate even when we disagree, that we continue to try to move that process forward throughout the negotiations process. When it comes to the duty to bargain, employers are required by law to negotiate in good faith with their employees' exclusive representative. As I said here, that's the FOP, concerning wages, hours, and terms and conditions of employment. We have the obligation on behalf of the city to meet at reasonable times and places, and we must demonstrate an intent to reach agreement or resolve questions arising under agreement. For the collective bargaining process, we have the ability to decide what it is that each side has the ability to decide what we would propose. We're not required to agree to any proposal or make any concessions, although I'll talk about kind of the impact if we were not to do that. The collective bargaining agreements are limited to 3-year terms, and as I said, we have to bargain in good faith. There are certain subjects that are mandatory subjects of bargaining, including a lot of the subjects that were necessary to reach agreement related to the anticipated role of the Inspector General. including a continuation, modification, or deletion of an existing provision of a collective bargaining agreement. Because the relationship with the FOP is so well established, there's been an agreement for 50 or more years with the FOP. That means that that agreement is very mature and it touches on a lot of aspects of our police officers' employment. That means if we want to change any of those aspects, the city has to come to the table and negotiate about those. There is also past practice, which is in the law. Under the law, a past practice is something that informs how ambiguous language in the CBA is applied. It can be, but is not always binding. Under the actual contract with the FOP Lodge 9, however, there's very specific language that has been in there for decades that says the city will agree to continue all existing practices and benefits during the term of this agreement and allows for grievances to be filed if the city doesn't follow that past practice. Why that's important is because even when there's not words on the page that specifically govern the relationship between the FOP and the city, there might be a past practice that governs that's kind of lurking in the corners. And so we have to be mindful of that as we do work and make changes going forward. There is a grievance procedure, just so that you're aware. At any time there's an unresolved question or dispute regarding the interpretation or application of the terms of the contract, that can be grieved, that goes through an arbitration process, and that can be those past practices that might not be necessarily memorialized in words on the page can also be grieved and would be subject to the grievance and arbitration process as well. For the Inspector General, one of the things that was important in this particular negotiations is that the Internal Affairs Bureau has always conducted its own investigations, and there's a particular provision that says that that investigation process cannot be contracted out, so we knew that we had to negotiate around that provision within the contract. If we had not been able to reach an agreement with the FOP, if City Council and the FOP members had not ratified the agreement over the last 2 weeks, then we would have been stuck in an impasse process. And so I want to talk a little bit about what that looks like so that you understand the importance of where we find ourselves today. It's important to remember that there are certain employee bargaining units, or certain types of employees who are not able to strike under Ohio's public sector bargaining law. And the exchange that was made for those who can't strike is that they would be subject to a binding arbitration process if the parties were unable to reach agreement. So if it's a strike allowed unit or permitted unit, then that unit, if the parties don't reach agreement, the employees can go out and strike, and that's how that dispute is resolved. When a unit is prohibited from striking, as are all of our police and firefighters and other public safety folks, then we're subject to an impasse process, which is a binding arbitration process. The first step, and I won't run through this in great detail, but the first step is if either side had not accepted the agreement over the last couple weeks, we would have been off to a fact-finding process. The fact finder is an arbitrator who is appointed by the State Employee Relations Board to serve in that capacity. Typically, it takes a period of time for the arbitrator. We get a panel of 5. We have to strike with the union, and then it takes time for us to schedule that hearing. In this case, we would have anticipated the hearing by the time we got there would have been several weeks long because we had such critical issues on the table. The fact-finding panel then after the hearing, issues a report and recommendations. Those recommendations are not binding. However, both sides have to vote on whether they would accept or reject the recommendations of the fact finder. In a situation like this, we anticipated, and thankfully didn't end up in this place, but that would have taken 6 or more months to get through the process. So that probably would have taken us into the first quarter of 2022. If either party rejected the fact finder's report and recommendations, then we would go to a second stage, which is called conciliation, and that is binding arbitration. Conciliation, we get a list of 5 arbitrators. Again, we have to strike and agree with the FOP on who's going to serve in that capacity. We prepare for and then present a series of testimony and hearings to support each side's positions. We expected that would take some time again. And then we wait for the conciliator's determination after that process. There's no time limit for how long it can take a fact finder or a conciliator to issue a decision. And once the conciliator, if we were at that point, a conciliator would issue a decision, that would be binding. And whatever it was that the conciliator put down on the piece of paper would be what governed the contract between the city and the FOP. Importantly, when we get to the conciliation route, a fact finder can kind of split the baby. They can say, well, I don't quite agree with the city and I don't quite agree with the FOP, so I'm going to find a wise place in the middle. By the time we get to conciliation, the conciliator is only allowed to choose between what the FOP has proposed and what the city has proposed on an issue-by-issue basis. So if the city came in and said, this is the easiest example, a 0% wage increase, and the FOP said, no, we want 10, then a conciliator can only choose between 0 and 10 and nothing in between. You can imagine that when we're talking about far more nuanced things like the role of an inspector general or the role of a civilian review board, that can be a very complicated and risky process. We anticipated that process, if we were to go through it, would have taken us into the second or third quarter of 2022. And we had some real concerns, and by we, the administration had some real concerns about dragging that process out, and felt that really coming to an agreement, if at all possible, if we could reach the things that we needed to reach to allow you all to do your important work, that would be critically important. So what do? I'm sure you've read a lot of newspaper articles about it, and I'll give you a high-level review, and I'm happy to answer any questions you may have, because I know it's a pretty important thing. From our chief negotiators, our chief negotiator was Ron Linville. He's my partner at Baker Hostetler. Mark Fester is the grievance chair for the FOP Lodge 9, and he served as a chief negotiator for the FOP. The prior collective bargaining agreement was set to expire December 8th, 2020. We started negotiating before that. We met dozens of times, I want to say it was over 30 times with the FOP in trying to reach an agreement, and had a few COVID-related delays along the way, trying to keep everyone safe and healthy. We were able to reach that tentative agreement on July 15th, 2021. That's when it was signed by both parties. And as you know, that agreement was ratified by both the lodge, the members voted first, and City Council, who voted last Monday to approve the agreement. So the big changes, the most important and the most critical for the work that you all are here to do, is that we have the ability to have an inspector general with authority to conduct any administrative non-criminal investigations and to compel attendance and participation of officers. So when I was talking about past practice, I mentioned that investigations had typically been conducted by the Internal Affairs Bureau of the CPD, but we have now negotiated the right for an inspector general, a civilian, to go ahead and do those investigations as he or she sees fit. We have negotiated the ability for the Civilian Review Board to have the authority identified by the working group. We've also negotiated specifically for you all to be able to be involved in both disciplinary hearings and grievance hearings, to make sure that you could participate as you all deem appropriate throughout the process related to an officer's potential discipline. We secured the right to conduct post-incident drug testing following officers' discharge of a firearm in the line of duty. That wasn't something the city was able to do under the prior CBA, but now post-incident they will be able to conduct that, and we think that's a pretty important development. We created significantly more management rights as it relates to the body-worn cameras. So previously, you could have a 1-minute look back on a body-worn camera. So if an incident occurred, you could look forward at following that incident, but you would only be able to look back 1 minute before the officer turned on the camera. And that was only video, no audio. Under what we negotiated now, you would have a 2-minute look back, both audio and video, but then also an ability for there to be an administrative review of the body-worn camera. So if you just pulled it from an officer, hey, we're going to look at it, you'd be able to look at the 2 minutes. Or we can take that camera, give it to an administrator, have an administrator pull currently as much video as is available on that camera, which right now is about 14 hours based on the technological capabilities, and be able to review that entire 14 hours prior to the incident, just something that under the contract was not able to be done so far. We know that there's a continued emphasis on ensuring that officers are able to be stepped through progressive discipline. So An example would be if I have a written warning for some sort of misconduct, you would want the next time, maybe I wouldn't get a written warning again, but instead I would receive a suspension of 1 day and kind of move through that progressive process. There's some pretty restrictive provisions within the collective bargaining agreement, but this time we were able to extend that administrative use, so that ability to build on a prior suspension from 4 years to 6-year time period for incidents that relate to EEO or profiling issues. And we're able to maintain that record. It used to be 6 years, now we can maintain it for 8. So for those who are engaging in misconduct that leads to suspensions, which tends to be our more critical misconduct, we're able to use that longer. I know that there's been a lot of discussion about leave forfeiture, which is where when an officer was perhaps suspended, and maybe they would say, okay, you've got 30 hours suspension, the officer would instead be allowed to use paid leave and not actually serve the suspension. So just kind of forfeit some vacation time that they'd built up over time. We negotiated some restrictions on that, so there's now a restriction on the use of leave forfeiture by the chief for conformed use of force, EEO, or profiling incidents. So it would never be available in those particular circumstances. There's also some other ways that that can be restricted long-term, but from a contractual basis, we were able to move that to be more restricted. We negotiated the ability for the city to select, without regard to seniority, one officer for each recruit training class at the academy. So an officer who can come and participate and serve as maybe a mentor to a recruit training class, another resource. Each time that there's a recruit training class, there will be an officer who can come and participate in that without regard to seniority. So it's really the chief's choice. And the FOP agreed to withdraw a grievance challenging the extension of the probationary period for new recruits. The city has always had a 1-year probationary period, but that included the time that was spent at the training academy. So as training has become more and more intense, it's taken more and more time. So the officers were experiencing a shorter time period of probation while they were on the street. Now, the probationary period begins when the officer leaves the academy, so we have a whole year at the end of that academy, which I think will be really important for folks to observe officers as they learn this new job.
I have a question before you move.
Please, go ahead.
Under 1, what is the intent of compel?
The intent of compel attendance and participation.
Now, is that, I can compel, does that mean that they have to, or is it just a suggestion?
They have to attend and participate. Because they're law enforcement officers, there are some Fifth Amendment restrictions when it relates to criminal investigations. But for non-criminal, they're compelled. That means they have to come, they have to participate under the threat of potential discipline, including for insubordination.
Thank you.
Absolutely.
So you might want to go ahead and make the distinction between that and subpoena. Many people in our community thought that we would have subpoena power, which we don't. But again, with compel, if a person refuses to participate, it could absolutely lead to that person losing their job.
Correct. That's right. And the reason there's not subpoena power in the contract is because that can't be created through a labor contract. That has to be created through a legislative process outside of negotiations. So what we did was make sure that we protected the avenue, that if you are able to have subpoena power through a legislative process, there's nothing in the contract that will stand in the way for effectuating that power. So we just tried to make sure we paved the way so that that subpoena power can exist through a more a legislative means. Thank you. Any other questions? Yes, please.
You indicated involved in disciplinary, that we would be in disciplinary and grievance hearings. What does involved mean?
Yeah. You're able to participate and observe. Certainly, there's always an ability for witnesses to participate in disciplinary hearings and potential grievance hearings if you're invited to do so. But what we have made sure is that you're able to, at a minimum, observe and be there to see the process as it occurs. If you were called as a witness or as an interested party, then you would also have the ability to contribute in that space.
I would say that particular area will be further defined as we begin to do our work. I mean,
That's exactly
there's
right.
so much of how we do our work and what we do that is still not really specified. But as we move forward and begin to work, we will sort of answer those questions, working with the chief and others.
That's exactly right. So let me give you maybe a slightly more specific example as well. Our goal was, knowing that you all had a lot of work to do to figure out what your process is going to be, was to continue to just open doors and create pathways that allow you to define what that would look like and identify where there might be obstacles in the contract that could potentially keep you from doing what you might decide you want to do long-term. So there were previously restrictions on who could be in grievance meetings in Article 12. And so what we did was say it does not, however, restrict the Office of Inspector General's or Civilian Review Board members' attendance at grievance meetings. So previously, if we'd left it the way it was, you wouldn't have even been allowed to attend. We've created the ability for you to attend. And then as you define what role you want, you'll either be able to effectuate during the term of this contract, or we'll be back at it. So, and help kind of pave the way after you kind of figure out what makes sense going forward. Other questions? All right, so this part's a lot easier to understand sometimes than the non-economic substantive changes. But I did want to make sure you understood the economics and what was offered to the FOP. It was one of the things that we heard from the administration was we wanted to make sure that officers who are showing up and doing good work and doing a good job were also being paid appropriately and competitively. And so we negotiated this change. The first, under the collective bargaining agreement, an officer who enters employment enters at Step A, and then over the course of the next several years moves from Step A to Step F. So year 1, I'm Step A, year 2, I'm Step B, and each of those steps includes an increase in compensation. We negotiated a market adjustment for Steps A through C, which is $1,350 on the base salary in year 1, and then $1,350 on their base salary in year 2. For Steps D through F, so your slightly more experienced officers and potentially significantly more experienced officers, we negotiated a change of $2,350 on the base in year 1 and $1,850 in year 2. And then we negotiated the across-the-board increases. So effective December of 20, which is retroactive to when the contract expired, it's a 2.5% increase. This coming December, they'll experience a 3% increase. However, they'll also experience, there's a small group who still has what's pension pickup, which is where the city pays for a small portion of what the employee's share of their retirement contribution is. A tool that was used long before I started negotiating contracts to help employees. We've eliminated that, so it's effectively, for some officers, a 2.25% across the board. And then in December of 22, it'll be a 3.5% across the board increase. Our officers receive a lump sum payment for reaching certain longevity milestones, so having served for a particular period of time. We did modify that longevity proposal by adding between $100 and $400 or so onto their longevity payments. They receive, particularly in exchange for the body-worn camera changes, 16 hours of additional personal leave, and the police memorial holiday, which is essentially an additional 8 hours pay because we're a 24/7, 3-shift operation. We don't really see them have the ability to take that off necessarily. This is an important component in particular because when we talked about fact-finding and conciliation, a fact finder or conciliator, when considering how much a person should be paid, always looks to comparable jurisdictions to determine are they being paid appropriately compared to the others in the labor market. As much as we, over the years, consistently say it's really appropriate to compare Columbus to Cleveland or Cincinnati, or maybe Indianapolis, other places, frequently what we hear from fact finders is actually that they'd like to know what's happening in Central Ohio when it comes to wages. And so when we look at those Central Ohio comparables, our officers at CPD were 14th. Out of the 16 or 17 we would normally compare as far as their annual wages. That doesn't help from a recruiting standpoint. It doesn't help you get folks in the door, and particularly diverse folks in the door, sell them on why this is a good idea. And so we negotiated, once with these changes, By the third year of the contract, your top step officer, so your F-step officer, would move from just shy of $93,000 to $106,000, and that would put them around fourth or fifth in the Central Ohio community. So it's not even putting them at the top, but it's putting them at a more defensible position when we think both from a recruiting standpoint and if we were to find ourselves in a fact-finding or conciliation in the future, we'll be in a better spot there. Any questions on this part? All right. The last thing that we negotiated was a retirement incentive program. The only officers who are eligible for this are those with 25 or more years of service with CPD. We have a maximum of 100 participants. There's no minimum. Officers would volunteer for this program, say that they would like to retire, and then we will choose them by rank and then seniority. So we will begin with commanders. Say we had 5 commanders who said, I'm interested. We would take those 5 in order of seniority. Then we would go to lieutenants, sergeants, and then police officers if there were still spots available. The participants, once they elect and are told they volunteer and are told, yes, you're eligible to participate, they have to remain with the city for 3 to 6 months. This is to allow our new chief to have the opportunity to figure out where she might have some holes and what sorts of spots she needs to fill. And then they would waive all claims against the city, and the payment for this retirement incentive program is $200,000 less applicable withholdings. Part of the reason for this is that it was shared with us that a lot of officers are not retiring despite being eligible for retirement because they don't receive the appropriate amount of insurance to cover their insurance between retirement and age 65. And so we tried to find a balance between what would make this an attractive option and what would help them in that way. But more importantly, and what I think is really critical, is it's also, we think, going to open up a lot of opportunity for our more junior officers to move up through the ranks. So if we have several commanders who choose to avail themselves of this, if we have the opportunity for lieutenants to avail themselves of this, we will see a shakeup within the division, and that's going to allow for some folks with new ideas and real interest in working with our chief to be able to move up the ranks. And that was critically important for us when considering this program. Any other questions for me?
Will we be able to have a copy of the collective bargaining agreement for ourselves?
Absolutely.
As a brief question, is there a reason there's no minimum for the last offering towards the end?
Yeah. Actually, the retirement incentive program saves the city money. And so we did ask, well, we didn't. We asked the finance director's team to do some analysis to ensure that even if one officer took it, that there would be savings, that we would experience savings, and we would. So it's designed to ensure that both there's a savings associated, but then also that opportunity for movement. Thank you.
So I received a copy of the contract, and am I correct that it's 185 pages?
Yes.
Just because I still print, and when I saw the number, I went with it, sort of an executive summary from someone. But we absolutely can make it available to you.
Absolutely.
Suggesting we all study up on management rights and the grievance and arbitration procedure.
Jenny, is that it?
That's all I have.
Hey, thank
Unless
you.
have
Any other questions?
Thank you.
Thank you so much for coming and sharing with us today.
It's my pleasure.
You know, Judge Jackson, before we move forward, though, I do have a suggestion because I don't like having people behind me talking. So is there any way, that we can arrange this room so that when we have a guest, they can be in the midst of us so we can all see them face to face?
So I'm going to ask you to do me a favor. There probably are a number, and again, I call them housekeeping matters. So why don't you jot them down, and hopefully at the end of the meeting, so whether it's what do we do about the parking, and what do we do about this room, we'll see what we can do.
All right.
Thank you.
All right, thank you.
Laura Baker Morrish. Laura is the chief counsel for City Attorney Zach Klein's office. And full disclosure, I've known Laura since my days as the city attorney when she was a law clerk, I recall.
I believe that's
Kind of right.
Kind of right, okay? So she is going to, and Laura, if you would introduce the other two members of your team that are with you today?
I will indeed. I don't know where my PowerPoint is, though, by the way. How to get on there? Yes. So while Colleen is helping me find my PowerPoint, because I'm challenged in that way, I do have two other members of my team from the Columbus City Attorney's Office. I want to introduce them to you today and what their relative roles will be. Thank you very much. So as Janet said, and it is still hard for me not to call you Judge Jackson, as Janet said, I'm the Chief Counsel. I have been involved in working on the Civilian Review Board legislation, and I was also staffed the working group that brought the various recommendations that formed the basis of that legislation, and I worked with both council and the administration on the charter review language as well. So that's how I come to this particular space. I'm going to be assisting in getting the board up and running, making sure that you have bylaws, rules, regulations, that you think about process, how you're going to interact with the Inspector General's office, if there's additional legislation that is needed in order to effectuate the things that you want to do. I would be the one that would help in preparing that or getting some language together, and also fielding questions just about how you are acting as a board. And that's kind of what I'm going to be here to talk about today. Once I get it set and going and ready to actually take off and start doing the work of the board, I'll be happy to transition this over to my colleague. Robert Tobias is in the room behind you. Robert worked with Janet and I down at the city attorney's office. We both practiced before her as a judge back when we were much younger. But Robert is now in the general counsel section of the city attorney's office working with me. He advises a variety of clients throughout the city. And because of his background in criminal law, I felt that it was most appropriate for him to then take on the role of advising the board and the Inspector General when they get hired, because he has familiarity with law enforcement. Also to my left is someone who has a lot more familiarity with law enforcement. Jeff will be speaking much more to the group in the weeks to come, but this is Jeff Furby. Jeff is the police legal advisor. He is housed within the Columbus Division of Police. He advises on a variety of matters, a lot of them related to investigations, but also matters related to labor questions, employment questions. Basically, if it involves the Division of Police, it probably involves Jeff Furby. And so he will be here attending some of these meetings as well and participating and assisting in anything that you might need from us. Good?
We'll also be providing, I don't want to call it instruction, but review of certain matters with us. Am I correct?
Yes. Not today, though, right? Right, yes. But yes, he will be. So I'm here to talk with you today about something that's a little bit more mundane, but very, very important to your work. It's certainly important to the work of the city attorney's office to make sure that boards and commissions are set up to be able to succeed in their missions and not have to worry about running inadvertently afoul of some of the laws that constrain the operations of boards and commissions. Everything we're going to talk about today is with one goal in mind, and that is that we want it to be open to the public. We want it to be transparent. So the rules that we're going to discuss here today regarding open meetings and public records, all of it goes back to that concept of transparency and openness. And hopefully I can click on it. Oh, come on now. Right arrow. No. Left click? Nope. See, it's not just me. All right, maybe it was me. So the Columbus City Code requires all meetings of the Civilian Police Review Board shall be public meetings in accordance with the general laws of the state of Ohio pertaining to the requirements of open meetings of public bodies. What does this mean? As I just said before, openness and transparency are tantamount to the public records and open meetings requirements of state law. Our city code has adopted those provisions of revised code for purposes of the Civilian Police Review Board's activities. That means you are functioning as a public body, not unlike city council itself. When you meet in a group and when you have met quorum, which for a group of 11 individuals is 6, you are now functioning as a body. And when you have that quorum, you need to do that and conduct yourself in accordance with the rules for open meetings in the state of Ohio.
Morris, I know
Yes.
to this. but we were talking about it earlier, Mary. And actually, I had a meeting with another member of the work group that I see frequently, and she says, well, Janet, after your first meeting, aren't you going to get together? Aren't you going to go have dinner together? Or as Mary said, to have coffee?
Yeah.
And the answer is no.
No.
Okay. 5 of us maybe could go, and another 4, whatever, but we can't, as a body, do those kinds of social things.
Yes, and unfortunately, that is true. And it's not that you couldn't all be in the same place at the same time. It's one of those things, people ask me the question, well, what happens if we all happen to be at the same movie theater and we ran into one another? The issue is not whether or not you're in the same physical space with one another. The question is whether or not you are discussing matters that are part of the Civilian Police Review Board's duties and responsibilities during that period of time when you're together. So, if you all happen to have the same, you all have crew tickets and you have season tickets to the crew and you all happen to be at Crew Stadium at the same time, is there a violation of the Open Meetings Act? No. But if you got together at some point during the intermission, I think it's called an intermission, at the crew game, and you discussed a matter that was pending before the board, then you would be in violation of the Open Meetings Law. So the reason that we usually give the advice, that lawyers are always ultra-conservative, the advice is don't get together at all, because the question is, from the public perspective, is what else would they be talking about? What, these 11 individuals, what else would they possibly be speaking about when they're all together in one space? Clearly, they must be talking about something that's happening or before the board, and that places you in a difficult position when you're talking about transparency and openness to the public. So the Open Meetings Act requires that you conduct your business in meetings, as I just said, that are open to the public. A public body may include the committees or the subcommittees of a public body. So this is something that hangs up commissions and boards all the time. So let's take an example. You have 11 members on your board, and you decide that you're going to put together a committee for creating or drafting your bylaws. All right? And so you specifically assign 4 individuals to be on the committee for bylaw purposes, and you create that as a committee by board action. Now we have a bylaw committee. If those 4 members get together, even though you're not a quorum level for purposes of the board as an entirety, but if those 4 members get together for purposes of conducting the committee for the bylaws, they also must comply with the Open Meetings Act, because they are a committee of the Columbus Civilian Police Review Board. They have to function as openly in a public forum. They have to be able to be observed by members of the public, have regular meetings, all of that stuff. On the other hand, if 2 individuals of the board said, hey, let's just get together and talk about the agenda for this next week, or we have a question about parking. What should the answer be about how we're going to resolve the parking issue for the board? And kind of 2 members got together and said, let's figure this out. Do you have a committee? No. What you instead have is an ad hoc discussion among members. You don't have a quorum number of individuals. Those individuals can discuss and resolve that minor problem, take care of the operations of the board without violating the Open Meetings Act. So sometimes when you see, for instance, at public hearings, maybe 2 members of the city council, they have a 7-member council. So if they're at 4, they've hit their quorum. If you just see 2 of them, they're participating and they're talking about things that come before the council. Can they do that without convening a meeting? Yeah, because they are less than quorum. They're not part of a particular committee, and therefore they are not conducting a public meeting as the full body. Okay? A meeting. Now, this is the other big one that gets boards and commissions in trouble. What constitutes a meeting? So you'll have a situation where somebody sends out an email, right? I'm going to send an email to the group. Here's the next meeting. Here's the agenda for the next meeting. Does that violate the Open Meetings Law? No, probably not. It's an information that's coming from one individual. Here's the information about where the meeting is going to be located. It's public notice that's going out to everybody. What causes the problem? One member of the commission replies back to the entire group and starts discussing something that's on the agenda. Now what you have is a conversation among a quorum of members who are on the public body about an issue that is a duty of the particular public body, discussing your business. And you're not doing it in a public way so that anyone else can see it, and you're not doing it according to a meeting that has been prescribed. So you have to be very careful about your email communications. You have to be very careful to make sure that you are deliberating as a body and not deliberating as separate individual entities among members of the body. You are one group for purposes of being the review board, and you need to be a group that makes a decision about any particular matter before the board or conducting the business of the board, rather than breaking off into some little conversations like that that could run afoul of the Open Meetings Act if they go too far. Same thing with phone calls. Emails have become more of a problem just because of the ease, but it could be a text message chain, it could be a group text, it could be a phone call that one person calls one member and then they call the next member and then they call the next member. They call that the round robin, right? Oh, we didn't get together, but everybody called the next person down the line and discussed a matter that's business for the board. That could be a violation of the Open Meetings Act. So the best rule of thumb here is, yes, it is expected that you might have a conversation with a fellow board member. You're certainly going to get to know one another and understand one another and maybe even have a coffee. But if you are getting together in a matter that is more than a quorum, then it should be in an open meeting and you should be acting as a body. Any questions on that general concept? Moving on. All right, so let's talk about what a meeting is. We talked a little bit already about emails and telephones can sometimes lead to being a meeting, but what a meeting is definitionally under the Ohio Revised Code, it's a prearranged gathering of a majority of the members of the public body who are discussing or deliberating public business. So why is this important? In order for the actions of a board or a commission to be valid as a board or commission action, you must have a quorum of individuals present and voting on the action. And they must be present voting on the action at a meeting. So meeting informs when you are acting as a board. How are you not just individual board members? How are you a board? You're at a meeting. It's prearranged, so it has to be, and like right now we're looking at monthly. It generally should be determined or understood when meetings are going to happen. A majority of the members must be physically present. This had been altered a little bit for COVID, and you might have seen that where we were able to attend meetings virtually for a period of time. That emergency provision has been actually expired. I was going to say rescinded. It actually expired. And as a result, unless the General Assembly decides to take that up again, we are at the point under our city charter where we follow the open meetings provisions on that for that particular issue, and therefore we must meet in person in order to be a voting member. And it's also when you're discussing deliberating public business. This goes back again to what happens if you're all at Crew Stadium watching the Crew game. Well, everybody's there. It's a prearranged time. You knew when the game was, right? It's a majority of members of the commission or the body, but you're not there discussing or deliberating public business. So it has to be for that particular purpose as well. This sometimes comes up not in the Crew situation, but it'll come up, for instance, if everybody decides to attend a conference. So let's see that maybe there's a conference of civilian police review boards and members want to attend and learn something from that conference. Can more than a quorum attend? Yes. You could all sit in the audience and listen to the same piece of information because you're not there for the purpose of discussing or deliberating public business. The danger lies in what happens when the conference is over, right? When you run into one another in the lobby, okay? But it's certainly not inappropriate to listen and be among other individuals for that purpose as long as you're not discussing or deliberating. So that's what a meeting, what constitutes a meeting. We already talked about what constitutes a public body. We talked about openness and transparency and why emails and text messages or phone calls could potentially violate those. Now I'm going to move on and talk a little bit about what public notice is. For regular meetings, notice must include the time and the place of the meeting, and that's generally going to be taken care of for you. Most boards and commissions within the City of Columbus are staffed. Right now we have Colleen who is assisting the Civilian Police Review Board at this particular time. Eventually, when the Inspector General Department is flushed out, there will be an individual within the Inspector General's department who will be staffing this particular body. But it is just important that you know that this is going on in the background. Meeting notice must be given out with the time and the place. The city bulletin is one way of doing that. We also have a city webpage. The regular meetings should be held at prearranged intervals. And right now, I think we're on monthly with an occasional additional, but basically monthly. And special meetings can be called, or emergency meetings can be called. Generally speaking, then 24 hours notice must go out And the only thing additional about a special meeting is you also have to indicate what the purpose of the meeting is. So if it's just a regular meeting, it's just the regular meeting of the board and the time, place. And if it's a special or emergency meeting, 24 hours notice, and you also have to include what the purpose of the meeting is so the public understands what's going on in that meeting and why. The Open Meetings Act requires that a public body make all of its meetings open to the public at all times. With that, there are two caveats to that. Basically speaking, what that means is you can't have secret ballots, whispering of public business, round-robin discussions. We see that from time to time. Let's do a secret ballot rather than doing a hand vote. Well, that has been found to be a violation of the Open Meetings Act because then the public is not aware of who's voting on what and who voted yay and who voted nay. There are some specific allowances for not conducting your business in public. They are executive session and also quasi-adjudicatory decisions that are being made by a body. I'm going to talk about that second. Let's talk about executive session first. I've seen a lot of boards and commissions want to go into executive session basically to talk about things that are of a sensitive nature. But in fact, executive session is very specifically defined under the Ohio Revised Code in terms of what the allowable uses of executive session are. First of all, you must convene in a regular meeting and then vote to go into executive session. So I just want to let you know that if you ever do find that you need to be in executive session, you can't just call an executive session. You have to actually have a meeting, go into executive session, do the executive session, then come back into the meeting and recess out of executive session and continue on with the regular meeting.
Question.
Yes.
Must you openly disclose what was discussed in the executive session?
So the question was, must you openly disclose? Okay.
Yes, the question was, must you disclose what you discussed in the executive section openly in public?
You must disclose the subject matter. You need not disclose the entire content of what you discussed in the executive session, but you must make it clear to the public that we are going into executive session to discuss a personnel matter, or we are going into executive session to discuss if you were going to purchase a collective bargaining agreement matter. If there are matters that are defined as being within the permissible uses of executive session, you would need to make public what that specific purpose was that you're going into executive session for, but then you would not need to reveal what you actually discussed during that executive session. Okay? So the matters are, it must be limited to one of the following topics: personnel, purchase or sale of property by the public body, pending or imminent court action, collective bargaining matters, matters required by law to be kept confidential, we'll come back to that in a minute, security matters, hospital trade secrets, confidential business information of an applicant for economic development, that's not likely to arise. And the last one, I can't see with the glare, Veteran Service Commission applications, again, not likely to arise in this group. So relevant to the consideration of this group, you might have, on a given basis, matters required by law to be kept confidential. Here's an example of that. Let's say you have an officer-involved shooting, and at some point we have an inspector general who is conducting an administrative review of the officer-involved shooting, and there are matters that are integral to the officer-involved shooting administrative investigation that are themselves also law enforcement protected confidential information. Maybe it's still part of an ongoing criminal case related to either the officer or another individual involved in the shooting. Maybe there's matters that were part of that administrative investigation that implicate, for instance, social security numbers or information gained from leads or from a BCI criminal background check that may or may not be disclosable to the public at large. There might be matters that come to this board that could themselves contain information that you would need to have in order to do your work, but that itself may be confidential. And we will cross that bridge as we come to it, but that's the kind of thing that might be discussed in executive session. It might be that you would discuss most of the administrative investigation in public, and then you would go into executive session to review maybe some documents that might be sensitive or of a confidential nature, and then come back out and discuss in public the remainder of that investigation, just as an example. Similarly, personnel matters, one of the tasks for the Columbus Civilian Police Review Board is to hire this first Inspector General. So I know Janet will be discussing what that process will be like, but there might come a point in time where in the course of hiring the Inspector General, you want to conduct job interviews. Personnel matters are the kinds of things that can potentially go into executive session, and so that's an option if you choose that, to go into executive session for that purpose. Any other questions on executive session? Okay. You can see down at the bottom, there was one other caveat down there about the executive session. No votes and no official action may be taken in executive session. So let's put that for the Inspector General just as an example. Let's say that you had individuals who had applied for that position. You had narrowed it down to maybe 3 individuals, and you brought all 3 individuals to be interviewed in executive session. And you can, and again, that's your choice. And you conducted those interviews in executive session, and now the board wants to vote on who should be extended the offer. Well, even if you discussed in executive session after the applicants had left their relative qualifications and desirability for being in that position, if you were to actually move forward and vote that night on who should actually be extended the offer, that vote would have to be back in regular session. Okay? So that's just something to keep in mind. And again, public transparency, there's a desire to make sure that the actions of the board are publicly available to individuals who might be watching. The second thing that I was going to talk about, I forgot to put a slide in here on it, and that is the quasi-judicial aspect. So right now, the way that the Civilian Police Review Board has been constructed, you're predominantly going to be looking and making recommendations or overseeing and causing investigations to occur. So there's going to be a lot of opportunity for you to weigh in on various investigations, but at the moment, there is not necessarily going to, at this point in time, and that doesn't mean that won't happen, there's not necessarily at this point in time going to be a hearing per se. But as the role evolves, as the Inspector General comes on board and investigations are conducted by the Inspector General, and there's going to then be some decisions made about how the inspector does and does not work with the board, it may be in the future that there could possibly be a hearing. If there is a hearing that is of a quasi-judicial nature, then boards are able to have the entire hearing be out in public, but then if they want to then deliberate and issue a decision, that deliberation and decision could in fact be outside of the public aspect of the hearing. So we will get to that, cross that bridge when we get to it, but just keep that in the back of your mind. That is slightly different if there's actually an adjudicatory hearing. Okay. The Open Meetings Act also requires that a public body keep and maintain meeting minutes. Minutes must be promptly prepared, filed, maintained, and open to the public. They need not be verbatim transcripts. And you can see that we're actually filming everything that's going on here at Civilian Police Review Board. That can also function as a minute if you choose to keep those for that purpose. But there also must actually be some written minute notes, and that is what Colleen is here for today. And that's what somebody who is going to be staffing the board would be doing in the future. And again, that really should be about what were the items that were discussed, if there were votes taken, who voted for what, who made who made the motion, who seconded the motion, what was the vote. Those are the kind of things that need to be maintained in the minutes. In terms of filing and maintenance, that just means that they have to, because they are going to create a public record, which we're going to get to next, you have to make sure that they are kept and that they are kept in a way that they can be easily found again if necessary. In terms of file, that means they just need to be all in one location. So there should be, for instance, a dedicated drive or a folder or, literally it used to be filing cabinets and this was the minutes drawer. Whichever it is that's chosen, it needs to be kept in that manner so that from the public's perspective, if they wanted to see the minutes of the board, they would be able to do so. And, okay, so that brings us right into public records. Meeting minutes and records shall be maintained in accordance with the general laws of the state of Ohio pertaining to public records. The Public Records Act does the following. It allows for public inspection of state and local government records kept by any public office It excludes certain records from disclosure, and it provides enforcement measures if a request is, I can't see that, no, denied improperly. As a public body, you are going to be creating public records. The meeting minutes are obvious. The agenda that was created for today is going to be a public record. If you're writing your own personal notes just to remind yourself of what you learned here today, those are personal administrative notes. They're not likely to have to be maintained as a public record. On the other hand, if you are creating any kind of record of this particular board, once it's created, you have to maintain it, and it has to then be available for public inspection upon request. So think about this, emails. Again, let's go back to emails. There are some emails that are transitory in nature. Hey, can I meet you at 9 o'clock for a cup of coffee before we go into the meeting, right? It's probably not going to be a public record. We're going to talk a little bit about that in just a few slides because of its content. But you have to think about the fact that it's not the fact that it's an email that makes it not a public record. It's about what you're communicating. Public records can be any form. They can be email, they can be text message, they can be written, they can be slides, they can be video, they can be audio. They can be any form of record that documents. And then the question is, well, what makes it a public record instead of just any kind of record? Here we go. This is just why you have to do it. That's where I was going. What is a public record? Any document, device, or item, regardless of physical form, right, that was created or received or coming under the jurisdiction of any public office which served to document the organization, functions, policies, decisions, procedures, operations, or other activities. And that really is the key. What does this document do? So let me give you an example. Going forward, a civilian wants to file a complaint about a police officer-involved shooting, and a civilian comes down to the Inspector General's office to initiate a complaint. The civilian fills out a form saying this officer did X, Y, and Z, and I believe this violated my civil rights. And then the civilian then turns that form over to the Inspector General's department. Do we have a public record? Yes. And this is what hangs up groups from time to time, because the board didn't create that record, the Inspector General didn't create that record, but it is a record that was received by a public office serving to document the function of that office. The Inspector General's office is there to receive those kinds of complaints. And now that they have received that particular complaint from a citizen, and now they're going to be required to maintain that record, okay? So when you're thinking then about that email that I just talked about, all right, so I've sent an email, I'm going to meet you for coffee before we go to the board meeting. Is it created by an individual who is part of a public office? Yes. Is it a form that could be a public record? Yes, it could be an electronic record, right? But does it serve to document the organization, functions, policies, decisions, procedures, operations, or activities? What do you think? I'm going to meet you for coffee. No. Okay? Not a public record. Now, it's maintained by the City of Columbus. If you did it on your City of Columbus server, and this is where people get this kind of mixed up, it's still in the possession of the City of Columbus. If we got subpoenaed for it, and somebody wanted to see it under a subpoena, and the city possessed it on its servers, we might have to turn that over. But is it a public record that somebody could request? Our answer would be no, because it doesn't serve to document the functions, organizations, blah, blah, blah. On the other hand, if you email to a board member, hey, what did you think about that investigation that we heard about last night? I'm thinking maybe we should ask for additional information. And then the other board member replies, and it's just the two of you, so you're not violating open meetings, you're just having that conversation. Are you now sending an email that serves to document the organization, functions, policies, decisions, procedures? Yeah. So you really need to be cautious not that you shouldn't create a public record. I mean, I think public records are important. They, again, going back to transparency and the public understanding how a board functions. But you need to be cautious and think about the fact that you are creating one when you start to discuss the matters that are related to the board. And usually the way that I suggest that people think about that and why you should think about it is that sometimes if you are familiar with someone, you might say something more casually in an email, not thinking at that moment in time that it might be on the front page of the dispatch, okay? So just be cautious of the fact that you're now performing a public function. For some of you, you've done that before and that's familiar to you. For others of you, that's not the case. So recognize that when you're serving here on the board, that is a possibility, and you need to be thinking about the records that you create and the fact that those records might be a public record if they serve to document the organization, function, policies, decisions, procedures, and operations. Okay? There are, so I already went through those, sorry about that. Okay. What is required to properly maintain public records? They have to be kept and organized in a manner that can be made available upon request in a timely manner. There should be a records retention schedule. I've already reached out to the administration about that. We do need to create one for this department. So every department in the city of Columbus has a records retention schedule. There's a whole process for it. We will make sure that there's one for this department and board as well. And then they must be maintained and destroyed in accordance with the schedule. And what that means is that there are some records that the city keeps for a very long period of time and other records that the city destroys in a very short period of time. There are administrative reasons for that. You know, if you have a record that is a public record, but it's of limited administrative use beyond a certain period of time, it might have a destruction schedule of 90 days. A good example of that is there's a lot of video camera, and you're going to hear about this on the board. There's a lot of video camera across the city that takes video on various streets for security purposes. Well, unless it's specifically asked for to be preserved for a particular purpose, it has a records retention schedule that is very short because it gets wiped over. And there's a reason for that. It's terabytes and terabytes and terabytes of storage that's necessary in order to store and retain and maintain video. So that's just something to think about when you're receiving records on the board, but also about when the board and the department are creating records, is how long should these records be maintained and how long, when should they be destroyed and for what purpose. Complying with a public records request. Most public records requests are going to be handled by the staff who will be assisting the board. You're not likely as board members to get a public records request directly from an individual. However, that staff member, in order to comply with the public records request, may well need to reach out to board members who might possess those records. So you should be thinking again about if you are creating records, like let's say that Janet suggests and the board votes and decides that a committee would be appropriate for a specific purpose, and you are the chair of that committee. As the chair of that committee, if you are creating documents related to the work of your committee, then you need to be making sure that those documents are being maintained in a way that they could be requested upon a public records request. Again, the staff will assist you with doing that, but I want to make sure the board is aware of the need to do that. And if there is then a public records request, they might be reaching out to you to say, hey, do we make sure that we got all of the meeting minutes from the last committee meeting, or the correspondence that you engaged in, or the information you received that you've been working off of, that kind of information. Another key thing about public records. Public records in the state of Ohio are a little bit different from when you hear about Freedom of Information Act requests, and they often get conflated. A public records request in the state of Ohio is just that. It's a request for a record. It's supposed to be a specific ability from a member of the public to say, I would like the record that documents the agenda for the first meeting of the Civilian Police Review Board. That is a public records request, and they would have to be able to be provided that record. It is not a request for information, and sometimes we'll get those in, and let me give you an example of that. I would like to, under pursuant to the public records request, information regarding how many people the Civilian Police Review Board intends to interview for the position of Inspector General. That's not a request for a record. That's a request for information. They could turn that around and say, I would like the agenda for the Civilian Police Review Board where they listed all the individuals that they intended to interview, that would be a record, okay? So as those requests come in, we in the city attorney's office assist often in the fulfilling of those public records requests, but just so you understand, you're not then required to create a record to answer that request for information. You're only required to turn over records that are specifically asked for or that could be easily identified based upon the question. There are exceptions. So, as I said, the presumption is that everything is a public record unless it has an exception. There's a laundry list. I mean, this goes on for pages and pages in the Ohio Revised Code. But relevant to your work, just the kinds of things you should think about just off the top of your head as these requests would come in: medical records, trial preparation records, law enforcement investigatory records. That's going to come up here from time to time. Again, this is in response to a public records request. This doesn't mean you wouldn't be able to see the information. This is about whether or not it's going to get released to the public, okay? All right, I would suggest that everybody who works on a part of a public body download and reference the Ohio Sunshine Law Manual. They put one out every year. It's easily indexable. It's organized by topic. It's very readable. It has references to case law and to the revised code if you're interested in exploring it further, but it doesn't read like a legal decision. It reads as like practical guide, so it's a nice combination of the two. It's available online, and I would definitely suggest that you take a look there for both open meetings and public records are both covered there. Yes.
I had a copy of your PowerPoint.
Great.
When we were doing whatever. I don't think that it was made available to members of the board. And so and I don't want to overpaper you. As I said, you'll see me with notebooks and whatever, but would you like a copy of this? Then Colleen could just send it out to the members of the board.
Yep.
Which one?
The FOP contract.
Yes, yes,
Robert?
yes.
You generally mentioned this during the presentation, but I wanted to add on a little bit more in terms of, like, I don't know whether the board is going to get city-issued email addresses or work phones, and if so, if they're not, and they're going to be using personal cell phones.
We have city emails.
City email, each individual has a city
Yes, we each have a
email.
city email.
Right, so that'll kind of help with the issue of getting emails, and you should only be using that email account to do board work in terms of emailing, not emailing from your personal Gmail account. But if you're getting text messages on your personal cell phone, in some way, shape, or form, make some attempt to put them in a folder or isolate them so that if a public records request comes in, people aren't scrolling through your personal cell phone,
Right.
trying to pick out only the text messages that relate to your work on the board.
I'm going to ask Laura to sort of repeat that.
Yes.
Because you weren't mic'd.
Right, I'll repeat it.
And so for, again, our public record and for transparency today, could you do that?
Yes, I can do that. So what Robert was discussing was whether or not you had city email addresses, and we just confirmed that you all do have city email addresses. So it is advisable to use the city email when you're communicating about board work, because if you were to use a private email account to communicate about board work, it would not be protected from not being a public record. That's a double negative. It means it would still be a public record if it served to document the work of the board. And since you don't want to have people in the city attorney's office scrolling through your personal emails and personal text messages to determine whether or not it's in fact a public record, it's advisable to keep all of those things on the city servers with your city email accounts. It's just the easiest way to do it. Any other questions about that? Yes.
Thanks so much for this. One question that I think would come up or may come up is when individual residents of the city of Columbus reach out via social media or some other form to a member of the board, kind of what the process, what would you recommend the process be in those particular
Right.
instances?
So again, being the most conservative answer because I'm the lawyer, right? It's likely going to happen on social media. It's certainly possible that that could occur. If it's a matter that the board needs to consider as the board, then the best thing would be to direct them to the board and to a board meeting, and to come speak on the agenda, or to reach out to, if there was a committee that's dealing with that particular issue, to reach out to the committee chair, to be part of the committee chair. Because again, the problem is that certainly you could have an individual communication with a citizen and not violate the Open Meetings Act, but what you then do is prohibit the other board members from hearing the conversation, and then also it prevents other citizens from hearing the conversation you had with another citizen. So the desire is to make sure that these things all happen in a public forum. If, however, it gets to the point where it's an extensive amount of conversations back and forth, and this is what we sometimes see, maybe it's a matter that a committee of the board is hearing about is right now, and they reach out to you on social media in your capacity as the chair of that particular committee, and you respond back to them, you might have just created a public record, because it's really specific to, they think that they're giving it to the person who is chairing the committee, and they think they're giving it to you in that capacity rather than in your private capacity as just person on social media. And again, I can't say definitively it's going to depend on the context, but if you want to avoid all of that entirely, then it's really best anybody who works in the public to kind of keep those two things separate.
Great, yeah, just as a quick follow-up, because that's where I would think in terms of, especially if it is related to their specific matters that might be,
Right.
they don't want to be made public, at least there's a process for board members to then forward it on to the respective authority here, so that's made clear, so thank you for that.
Will be discussed when we get to the social media policy.
Yep, excellent,
Right.
thank you.
Any other questions on open meetings and public records? It's very exciting.
Thank you.
I've lived with it for a long time.
Yes.
Laura, thank you. As we move through our agenda, and you weren't down for this, but I know because of your specific role, I think you many times have to address it. And you probably, do you have a copy of the Pledge of Ethical Conduct?
I saw it, but I don't have a copy with me.
Do you want to just address it for a minute? Because what we're asking, I believe, board members to do is to sign and acknowledge it, and then it, I'm assuming, would go to Colleen for now. Pardon.
Yep, yes.
Or they, again, have, at your place today, there was the agenda, there is the Pledge of Ethical Conduct, and there is, in fact, the Social Media and Media Inquiries for Civilian Review Board. Are there any questions about the pledge? If not, would you please complete it and just pass it to the end this way? Thank you. Feels our first official act. Thank you. Now, we do have a social media policy. Thank you. That was basically prepared for us out of in the mayor's office. You see Robin Davis, Deputy Chief of Staff of Communications, and then Mel Crable, Director of Media Relations. If you'd like the opportunity to take a look, to read it, if there are any questions, concerns. Yes.
I did have a question, and this could be the lawyer and me, but number one, impair working relationships with the city feels a little vague.
Did you say vague?
Vague, yes.
Okay.
As far as, I think that number 2 and 3 seem to encompass what our responsibilities would be in a more specific way. And just as someone who tends to make constitutional challenges on a regular basis, impair just seems a little loose.
Okay.
this for the general public to see?
Certainly can be, it can
Yeah,
be
just, I
posted
think,
or.
just in terms of, for reference purposes.
So I'm going to follow up on
Gotcha.
the first one, and we'll probably bring it back. The document will come back. And Kyle, you want to know where members of the public can find this. Can someone?
I believe it'll be,
Okay.
I believe it'll be on the city website on the civilian board page.
Great.
City website, our webpage. Okay? Yes.
I don't know if it's appropriate now or, as we're discussing the social media policy and the Pledge of Ethical Conduct, or, when we have a section here under additional business. But basically, I would like to have a brief conversation about the function of this board. Specifically, are we functioning as a judicial board or as an advocacy group? Or, those are the two edges. And here's where I'm going.
Did this come up? I know that you made a request
Yes.
for us to have a discussion around mission.
Yes.
Am I correct? So is that,
Yes, generally, but it really, when I'm thinking about it, it has ethical implications as I think about the canons of judicial ethics and the sort of thing that would bind this group in terms of our public communication is sort of all-encompassing. I mean, it overlaps what we're talking about. So we can have the conversation regarding mission and then come back to this concerning social media policy, and it really has to do with our public posture.
okay. So I have thoughts about our second meeting, and I didn't have those specific words. So right now, looking at our second meeting, because I think it is important that we get to our bylaws. And Laura, have you sent out your draft bylaws yet?
Only to you.
Okay, then I think that before the second meeting, you would receive the draft bylaws. You have in fact received the ordinance that was passed. And you also received, I believe, the recommendations from the working group. So at our second meeting, and Laura will lead this, but when you really get into the ordinance and us, to me, it really, I don't know if you'd say mission, but it really talks to the work that we are to do. And so I thought that that conversation could be interwoven into that we'd have, we are going to have several sessions, such as the one today, where basically we're going to have presenters. And we will have a presenter at the second meeting, I guess, with Laura. But I thought because of the topic specifically of the ordinance, it would give us the opportunity to ask more questions amongst ourselves, have discussion about that. So since I've shared that, are you comfortable with that for our next meeting?
I wouldn't mind touching upon it a little bit just ahead of kind of getting the draft of the bylaws, because I do think that's important as a first meeting. But I agree, kind of diving into the details, the second meeting might make sense. But only because I think some of this relates to specifically around some of the social media policies. I do think it might be worth having a little bit of a discussion, but I'm open.
Okay, so this is where we are today. We are at 3:32. This meeting will end by 4 o'clock. So one of the things about your chair, we start on time and we end on time. Now, I have to have some conversation with you today about our meetings. And just, I don't think that one meeting a month for 2 hours is enough for us to really get started. And so I'll just throw out this option and then I'll come back. Maybe if we took the one meeting and extended it from 2 until 5, giving ourselves another hour with maybe a 10 or 15-minute break, versus trying to add a second meeting to the month. I see it would still stay the first Tuesday of the month. That worked for everyone. So for the month of September, And just in terms of heads, would it be okay to go from 2 to 5? Yes? So we'll do that and see how that works. That was just one item. Another item about meetings. There is a meeting that is essentially an all-day meeting. Commission members have been through this. It is held at the Police Academy. For about 3 hours, we go through the ABCs of policing, and that is presented. It has usually been by a commander and a sergeant. I don't know. I have not been told who will be doing that at that particular meeting. Break for lunch, and then we actually participate in scenarios. And Laura, I don't know if you have the answer, because I know, George, you don't have a microphone. I have forgotten what MILO is.
Milo is a computer-aided scenario training program.
So there are two types. The scenario, we become the police officers, but you're out and you're moving around. And then with Milo, it's computer generated and it's in a room. I assume it's going, and I would like to have this training completed by the end of September. I don't know how we're going to go about deciding the date. Maybe the best way is to figure out which day of the week is the best, for each of you, and see if we can do it that way. But Colleen, we will need to find, and we have to coordinate, of course, with the police department, on this. But would like to get that done before the end of September. That's a part of our training. Yes.
I'm glad you brought that up, because prior to coming today, I had a question about some of the information that we received in the email, or one of the emails particularly about signing off on ride-alongs.
Yes.
And this activity fits into my question about that. What is the purpose for us doing that in context of this board? That is a little confusing to me. And so without having a clear definition, I don't have it yet, but a clear definition of what our board is doing, these activities, I'm curious about what they're for and how we are to use the information that we gain from them from our work and what we're doing.
The simplest answer for me is that it is required in the ordinance, significant training for us. And I would say that it is an appropriate request from the police department that we be trained. I would turn to either maybe Chanel or Brooke to say, what did you get from both of those as a commissioner? And maybe I'll start. I did a ride-along. I did second shift. The substation is on Main Street. During that shift, there was a significant incident that involved a very, young person. So just being there and observing I was with Sergeant Justin Coleman. Just being a part and seeing and the decision-making process and everything gave me a much better perspective of what it's like to be a police officer. The training at the academy, a part of it could be around the split-second decisions that have to be made. So it is giving us exposure to policing in a way that we probably have not been exposed before, unless you are a TV junkie like me and you watch all of the shows, which isn't real life. I personally think it is extremely important for each, and I even said to our retired police officer, I said, you need to do the ride-along. You need to do everything. Again, it may give you a different perspective now that you have retired. I don't know if that fully I mean, that's my perspective, and other than what the ordinance actually requires.
Follow-up question?
Sure.
So with that, are we also, for the members of the board, I live on the east side as well, like a block from that station. So will all of the members of the board also, I don't know what this training would look like, but also be involved in training for how citizens of those areas interact with police? What it feels to live in a highly policed area to further our work? Is that going to be offered as well?
You know, so much of our work at this point is unspecified, but the question that you raise, and I'll share with you that as I've looked at our work, this area is probably the most challenging for me to know what it's going to look like. This whole part about our role and bringing about community trust between our citizens and our and the police. There was a part in there, but I don't think it's in the ordinance now, where we were to actually, and I don't want to call them hearings, because I don't want us to be in a building bringing citizens in. There is an obligation for us to go out amongst, again, all communities. So that is work to be determined and shaped. I will probably end up saying this on more than one occasion. We don't have the answers yet, we collectively, as to what all of our work is going to be and to look like. Kyle, I'm sorry. Yes, I heard.
Really quick, a couple things. So I've gone on a ride-along as well. I think that based on my perspective prior to that ride-along, that drastically changed my perspective on policing. A lot of things I think that we don't think about is we always know the what. We know what happened, but we don't know the why. So we don't necessarily understand why a police officer does a certain thing a certain way. We just know what happened. And so I think that's really critical in this work. And I think that, and I hope that you all would agree, I think similar to policing, this training should be ever evolving. So as we go on year after year, as a group, we should be coming together to talk about what additional training needs we have, because what you just brought up was a really great idea. Because I think it's imperative that we all look at this from a lot of different lenses and not just our own. So, thanks.
Let's see. I can see Kyle's hands. Someone's going to have to help me out. Mary, and then Kyle.
Just very briefly, having been a public defender and dealing with, for 36 years and dealing with indigent individuals, I think what you bring up is an excellent idea here. Because having had the opportunity to sit across, first doing municipal court work and then doing felony work, sitting across an individual who is poor and having had contact with police officers. And some had, when I went over to the jail to see them, had visible stuff on their faces, et cetera. And then when you talk to them, when you watch the videos, you know what they're telling you is true, and you know that they got the short end of the stick. So talking to the individuals, you know what's going on, and you're hearing their side of the story. And then you have an opportunity to see the officers in court. And I've had police officers come to court and speak on behalf of my clients. So you see all sorts of things. So we need to do the ride-alongs, and we need to get the perspectives of the officers, because there's really good officers out there who really try to help. The ones that came to court to help, to try to make sure that the individual didn't get that felony conviction, to ask the prosecutor to give us a misdemeanor and to help out. So those are the good guys. And then you'd have the ones that came over there wanting a felony conviction for some little possession of drug or something like that. So, and I think that the ride-alongs and getting the officer's perspective is great. But then you brought up, how about the individuals that live near me in my neighborhood? Can we get their perspective? And I never thought of it. That's great. And then I thought of myself sitting across from my clients and thinking, yeah, we need their perspective too. And that's how, and this board, what I'm seeing here is fantastic. All these perspectives that we have is great. So that's what I wanted to say.
Kyle?
No, thanks so much for bringing up that point earlier. I mean, I do think this will go into the question when we talk about the role of the board and exactly the type of body that we're going to be. And I think is important as we think through future iterations of this board in particular in terms of what's a required training and what is optional. I think that is important in terms of perspectives, especially as we think through racial equity trainings, conversation about these issues as well. But I think it is an important point to bring up, especially that we made this, understand that this is part of the ordinance and some aspects to it, but we did make kind of this determination, and we haven't yet worked through exactly what setting as a board we are. And so I completely understand in terms of why there might be some hesitance around requirements for ride-alongs. Thanks.
I think, Mark, did you have your hand up? No? Yes.
Yeah, just real quick, you know, in the world of investigation, you know, transparency is going to be critical. That's what the public is looking for us to do, right? In order to do that, you have to understand all sides. Our brother down here on the end, I thought, brought up an excellent point, and I look forward to that, actually. I don't see how you could do a fair and complete investigation without, you know, knowing how policing is and what the training part of that is.
Okay, thank you. Reverend?
I just wanted to say, you know, I think it's imperative that as we move forward and we try to put all these viewpoints together, that we don't allow the outside to form our opinions before we get in this room, because I heard someone talking about, you know, dealing with the media and whatnot. My phone's been ringing off the hook, and people have been wanting me to do interviews, and I don't even call them back. Because I don't, and I got my colleagues, and I know Pastor Nathan, you probably have this same thing. You have your colleagues, and all of them are bombarding you with their perspective of things. And, you know, you just have to keep your mind somewhat neutral until you're able to really sit down and get into these meetings, and we start forming the rules and regulations and getting facts on both sides of the table. So I just wanted to bring that up.
That is a viewpoint that I personally share. I have turned down interviews consistently. And one of the things I've said to them is that I'm not going to be interviewed on something that I don't really know about, right? I'm just speaking for Janet Jackson. I'm not speaking, you know, for the board. I may have a view about something coming into this room that I want to share and discuss with you, but that's not what I should be espousing to the media. And again, we have to shape. I mean, that's our role. We have to shape, create, and build our own civilian review board. That will not be done overnight, and we're going to have many discussions, may not always agree, but that's initially our role right now. I have said publicly that to me the two most important roles for us as the board is the creation of a strong board. You know, we're not going to necessarily recreate the wheel, but we're not going to take a model from this city or that city and say, this is what we want. Our responsibility is to build it. And Kyle, I think as you maybe mentioned, and maybe Randall, we'll go back and look at it at different times, but initially we have to have this solid foundation. The second, and I'm not so sure it's not the most important responsibility we have, is the hiring of the Inspector General. That he or she has to be the very best. And if you weren't aware, and this hopefully will also be at the next meeting, this will be a national search for the Inspector General. I believe, again, at the last meeting of City Council, there was actually, I'll call it an ordinance that provided for the hiring of the search firm. I have actually seen a preliminary, you know, job description that you will also, you know, see. But those are the two critical things that we must get done with a lot of hard work on our parts. Brooke?
Yeah, I was just going to speak directly to your question about the training itself, having been through it, I can tell you that it is high stress. It's adrenaline provoking, anxiety provoking. There were some of us who, after going through it, it took a while to work down afterwards. I flipped a grown man onto the ground because I didn't want to use a weapon. It's very pressure filled. So I say this, that it's necessary to take care of yourself. And so I would just be aware of that it does spark a lot of internal emotions and actions, especially if you have not had positive engagement with law enforcement in the past. And so I went through the Milo simulation, all the scenario-based simulations. They do put a weapon in your hands. It fires blanks. So those are just some of the things you should know before you walk into the door, that it does feel some kind of way doing it. And so I would suggest very much so, just people, if that is going to be triggering, that you take care of yourselves, because it's not like a fun, fair ride. And then when you juxtapose it against the first few hours of the morning when you hear about police training, it does highlight a lot of areas that law enforcement aren't getting adequate opportunity for calming down after incidents. They're expected to go back out and right after answering a call, go straight out to something else without any real trauma-informed coping mechanisms. And so it does, I think, inform us as to where some gaps are in what officers receive. So.
I believe Dr. Jones had a particular reaction during training that involved throwing a weapon?
Yeah, I can elaborate. So I echo everything that Brooke said, and it definitely is an eye-opening experience. I did not want to use my weapon in the training, and so I actually threw it at the quote-unquote bad guy. And so I have now become the joke of the ABCs of policing training, but it's okay. The guy lived. That's my perspective. But I also want to speak to the issue with the ride-along. I did take a ride-along, and I don't know if all the stars aligned that evening, but I experienced a home invasion, a homicide, a foot chase, and somebody escaped from out of their handcuffs. There was a lot that was jam-packed that happened in that day, and those were all back-to-back calls. So it provided an additional perspective on just what police officers have to deal with on a daily basis. I was able to go home, but, I rode with Officer Alex Mottinger that day, but he had to return the next day and do that all over again. And so it does provide some additional context, and like Brooke said, identifies some significant gaps in areas of improvement. And then the last thing that I wanted to mention was your comment that you made about us receiving the perspective of the community. One of the things that, put my academic hat on, that we at Franklin University did, we partnered with the city attorney's office, and we developed a community immersion training for Columbus Division of Police to provide them with a perspective from the community. I think there may be an opportunity to perhaps even modify that and reduce it a little bit, and we provide that training for the Civilian Review Board, because it provides the perspective of the community. We incorporate poverty simulations and do all sorts of things so people actually understand, what it feels like to be policed and what people have to do, and some of those other social determinants of crime that may contribute to an event happening. And so we can talk about that and see if that may be an opportunity.
Good. It's getting close to 4, and I wanted to address, it's not a matter. You were sent 2 forms, a criminal record check and the ride-alongs. I think all of those forms have come back, and Richter Speaks, you would need to get to a microphone, because I didn't know if you wanted to address anything about those. One, for example, around the ride-alongs. How is that actually accomplished? Who's going to be contacting each member of the board? I put in, I think I did, a request for a particular part of town and second shift, but those other types of things, who's going to have the individual conversations with folks?
Madam Chairman, you just tell me when, and my thought is I will have each member contacted. We will get convenient times and dates, and areas of town that folks would like to do a ride-along. So that is not a problem. Just let me know when you would like that started,
Well,
and we'll start the contacts.
I would have your staff person start sending individual emails to folks to get the conversation started about that. And just for everyone's purpose, we're in good standing when it came to the criminal record checks. I knew that you would be very interested. You would be very
Great. We were
interested.
worried.
In that. Before our next meeting, we'll work with the team around parking, the configuration of the room, and when it comes to the room, there was some discussion about putting window treatment on these windows. Would like to hear back from the board, and you could just send me a quick note. Does this bother you? Do you want the window treatment? We want you to be very comfortable. I'm seeing the shaking of heads from over there. Okay, fine. And I think those were the things that I needed to touch base on. So coming back to the conversation around social media, I would say, because we're running out of time, that would be the first item on the agenda for the next meeting. That's where we would pick up. And if you want to help me, flesh out what is the agenda item. I don't think it's just, social media policy, or it still might be better for us to have the conversation around the ordinance and really going through our work. So I will work through that. If you have thoughts, let me know. Is there anything else about today that someone question, comment?
Really quick, your question about the window, of course, I'm not facing a window today, so I was looking at you guys to see what you thought, but something to think about in the future. I mean, there could be a situation where there's something very controversial, and there are 200, 300, 400 people outside this window yelling and screaming. I mean, you can hear the cars going by, but it's something to be mindful of. I mean, we're right here on the first floor, so I just wanted to throw that out to the group.
I found the traffic distracting.
I found myself somewhat watching the windows because we had people who were in trucks with windows down, and I often think about some of the things that could happen. So, yeah, and then those of us, with your backs to the window, just.
So let me just share with you kind of the why of this room. For the Safety Advisory Commission, we moved around, and we found that challenging. Sometimes we were at the Jury Hammond Building on East Broad, I think, or we were next door in the Michael Coleman Administrative, Building, and that's where we would have preferred. But that building is used significantly, and we could not find a consistent time for us to meet there. And then Richard Blunt, who is with the mayor's office, found the space that is rarely used, we discovered. And so that's why we made the decision. I guess as we go along another meeting or two, if it's problematic, we'll need to go back to the drawing board to see if we can find something else. Maybe even, Richard, looking at, again, next door, we may have already done this, but was there a time that we could have it each month? We'll see. But we'll take that into consideration. Anything else around just the logistics of the meeting? Let me no. Let me share this with you. And as the former city attorney, especially, they can't use city funds for coffee or just about anything. Now, I think I know where the funds came from this. The mayor's making us comfortable with not city funds, but other funds. So I would really suggest to you that the last stop that you make before you come is to bring your cup of coffee.
We don't want to bribe you with coffee.
No, but good points to ask those things. Anything else? Well, then again, it has been just great being with you for this first meeting. It is yes, Robert?
Should I be a stickler now about motions to adjourn and seconds and all that stuff? or
Oh,
we'll
do we
wait
need
for-
to do that?
Or we'll wait for the second one?
No, if we've got time. Uh, I did. The chair will entertain a motion to adjourn the meeting. I think there's Dr. Chanel Jones was the moved, Mark Fluharty did the second. All in favor indicate by raising your hand. Any opposed? Motion passes. We are adjourned. Thank you, Robert. You know,